Assalamualaikum and hi. This is the chapter 11, the law and practice relating to terminations of employment, part 2. Okay, domestic inquiry and principles of natural justice. The recommended procedures for domestic inquiry are investigations. When an employee is accused of committing a major misconduct, a full written report providing details of the misconduct should be prepared. Domestic inquiry. The Employment Act Section 14 states that an employee can be dismissed on the ground of misconduct after due inquiry. These sections of the law was interpreted to mean that a formal trial called a domestic inquiry should be held in the workplace before imposing the penalty of dismissal. For domestic inquiries to be useful, it must be properly organized according to the principles of natural justice. In Award Number 93 of 1985, the court said the concept of natural justice have two basic components that are the rule requiring a fair hearing and the rules against bias. The holding of domestic inquiries ensures that all evidence against the employee is examined carefully and truly by a group of independent persons, and therefore there is less possibility of an innocent employee being dismissed. Employer can be confident that he has treated his employee justly and fairly. A fairly conducted DI will fulfill the following requirements. 1. The worker has the right to know of what he is accused of. Therefore, he must be presented with a written charge sheet which lays out the nature of the misconduct. 2. No one should be condemned unheard. Does the worker charged with misconduct have the right to speak in his own defense or to have a representative speak on his behalf? 3. The worker must be given time to reply the accusations. On the one hand, domestic inquiry should not be unduly delayed. 4. An unbiased party must conduct the inquiry. Inquiry officer should be appointed to preside over the hearing and to act as chairman of the panel inquiry. Once the inquiry has been held and where the employee is found guilty, the employee must be decide on a suitable penalty. The punishment must be appropriate to the seriousness of the misconduct and take into account any mitigating factors such as the length of service of the employee, the pre-record of the employee, whether there was any provocations leading the employees to commit the misconduct. Employer can penalize employee guilty of misconduct in the following manners. Oral warning, which should be combined with counseling, which is a penalty suitable for an act of minor misconduct. Written warning, downgrading or demotion, suspensions without pay for not more than 2 weeks, and dismissal. The penalty of suspensions without pay for not more than 2 weeks is provided for in sections 14 of the Employment Act 1955. Next is disciplinary actions for poor performance, including probationers. When a manager identifies a worker whose work is unsatisfactory, it is essential that the manager makes an accurate analysis of the weaknesses in the worker. No domestic inquiry is necessary. Employee must be warned and given the opportunities to improve. Procedure to terminate employees on the ground of incompetence. 1. Issues written warnings to the employee. statement that if the employee does not improve his work performance, he may be dismissed. Provide the employee with appropriate training, retraining, coaching, or counseling depending upon the cause of the poor performance. Decide whether to give him further time to improve or to dismiss him if no improvement is made. Provisions. So here is a requirement stated in the offer letter. Okay, employee will want to monitor employee's work to see if he is capable of doing the job for which he is hired, as well as whether he can adapt himself to the cultures of the organizations. Employees, when applying for the jobs without knowing whether he is able to cope with the works assigned and whether they will be comfortable with the social environment at the workplace. Notice period prior to the terminations of probationers is brief, normally 24 hours notice. Okay. The rights of probationers. Okay, when an employee is first offered a job, it is common practice to place him on probation. This requirement will be stated in the offer of the employment and is intended to allow both the employee and the employees to give each other a trial period. If the employees turn out to be unsuitable for the job during this trial period, his services can easily be terminated. Disciplinary actions for probationers. A probationer should not be dismissed during his probationary period except for misconduct. Probationers should be given suitable training, okay, should be given coaching and also guidance. Performance of a probationer should be monitored and approved by his immediate supervisor. If the employee's performance is unsatisfactory, he should be given warnings. Okay, that's all for this part. Thank you.